Hi guys, good afternoon. क्या हालचाल? Screen is visible to you. Good afternoon, Ish. Is my screen visible to you? The whiteboard is visible to each and everyone. Just a minute. Just a second. Just a second. I think yes. Now it's perfectly visible. Okay. Hi Kajal, how are you? Shambhavi, good afternoon. क्या हालचाल? All good? Yes. Now it's visible. Now it's visible. Fine. Okay, so let us start. Today we are going to revise Specific Relief Act 1963. Before we start with the concept, before we start with the statute, now what do you understand by Specific Relief Act? What is the purpose of this act? What is the object of this act? What is the requirement? What is the need of this act? When we are having Indian Contract Act, we are having the chapter in the name of remedies for breach of contract. Yes, so we are having, because when there is a contract there is a possibility of a breach of contract. Once there is a possibility of a breach of a contract, we need remedies. Now then, why do we need a special act under the name of Specific Relief Act? Now when we are talking about remedies under breach of contract, then under Indian Contract Act it is providing us the remedy just like damages or sometimes suit of quantum merit. Now but sometimes money consideration, money compensation, money damages is not sufficient. Money damages are not sufficient because of the peculiar nature of the case, peculiar facts and circumstances. Their Specific Relief Act plays a pivotal role. Specific Relief Act plays a pivotal role. Now, under Specific Relief Act, you are having multiple remedies. You are having multiple remedies. Now, when I am talking about any act, I always say pay attention towards the nomenclature. Now, here we are having two words, specific and relief. What is relief? So, relief means remedy. Remedy in case of any dispute or in case of any facts and circumstances, relief is remedy. Now, under Specific Relief Act, you have multiple reliefs provided under SRA 1963. Number one is recovery of possession. Recovery of possession. Number two is specific performance. Specific performance. Next, sir, rectification or cancellation of instrument. Rectification, cancellation, rescission of contracts. Next, sir, declaratory relief. Next, sir, injunction, preventive relief. So basically, these are different kinds of relief which has been granted under the statute of Specific Relief Act, which we are going to discuss it one by one now. Okay. Now, when we are talking about Specific Relief Act, okay, Shalini, my screen is not visible to you. I think it's visible to each and everyone. Shalini. Those who have just joined, just say hi also. No? Yeah, I guess it's visible to me as well. I'm seeing on another screen. Check your connection, Shalini. It's not clear visible. I guess there's an issue at your end. Just check it once. Okay. Just disconnect it and join it again. Maybe sometimes some technical errors at your end. Okay. Now, when we are talking about Specific Relief Act, the object of Specific Relief Act is confined to the class of remedies. Now, what are the remedies? These are the remedies which have been provided by Specific Relief Act. Under SRA, our scope of remedies are limited to these points as per the situation, that as per our requirement, as per our situation, this is the medicine for our problem. Now uh, we have to confine our vision up to these reliefs. Okay, now specific relief early, sir, specific relief uh, you are saying specific relief is 1963. Earlier it was there. Yes, earlier it was there, but later on specific relief amendment bill was also introduced in the parliament way back in 22nd of December 2017, which was passed by Lok Sabha and Rajya Sabha. Finally, it received an assent on 1st of August 2018. The Parent Act was Act of 1963. Amendment Act is of 2018. Earlier it was 1877 Act, pre-independence era. Now, sir, when we are talking about specific relief, we are talking about the different remedies. Now, while you are appearing for examination, you need to pay attention towards these reliefs and the tricky points in that. One thing is important to note here that when you are appearing for any examination, supposedly you are preparing for Madhya Pradesh judiciary or doing rapid revision for Delhi judiciary or any so. Now, in that eventuality, specific relief act is such an act जिसके अंदर you do not have to go into the details or go into jump into the depth of the sea and to understand or interpret the laws. No, specific relief act is quite simple, but the main part is the tricky points. In specific relief act, there are so many tricky points, and specifically, if you see the past year paper analysis, in that situation, the examiner, the states are asking those questions where they are expecting that students will slip. They are giving the options that yes, student will be a trap in that particular situation and he'll make the wrong answer. So that you need to keep in mind. Therefore, well, we are going to start this specific relief act. So in that act, you need to pay attention. Joe, whatever points I'm saying, just jot it down in your notebooks or just pay attention towards your screen or whatsoever, wherever you're writing down, just mark it. Okay. Now let us start one by one with the first remedy. Now, when we are talking about specific relief act, you will see the structure. In structure, firstly, there are parts. Among parts, there are chapters, then sections. Now, first, part number 2, chapter number 1 is talking about recovery of possession. Recovery of possession of property. From section number 5 to 8. Now, guys, one thing is important when you are doing specific relief act, the structure of SRA is an important, that these sections are related to recovery of possessions, these sections are related to preventive relief, these sections are related to declaratory relief. So sometimes a question comes, match the following. That is important for SRA. That is important for SRA. You need to, because it's quite simple as well and it is expected as well. Now, when we are talking about section number 5 to 8, chapter number 1 of part 2, one thing you important to note that this chapter is talking about possession. It is not talking about ownership. It is not talking about ownership. It is talking about possession. Now, possession means, sir, we know what is possession. Now, when we are talking about property, whether it is movable property or immovable, now we will bifurcate this term into two situations: movable property and immovable properties. If I write immovable first, then movable properties. When we are talking about immovable property, section number 5 and 6 will come into picture. And when we are talking about movable properties, section number 7 and 8 will come into picture. You know what is movable properties and what are immovable properties. ये आप लोगों को बहुत अच्छे से पता है. सेल ऑफ गुड्स में भी पढ़ा है, टीपीए में भी पढ़ा है, बहुत जगह पढ़ते हैं, जूरिस में भी पढ़ते हैं. Now, guys, here a tricky question comes. This is a question that sometimes they write a situation that Mr. A lost his car, Mr. B unlawfully took a car of Mr. A and he wants to recover the possession under section 5 or 6. Can he do so? Many of you will mark it. No, the simplest answer was because that was a car, so it will go into movable category. This is the minute mistake, and with this mistake the entire question can be wrong, and this is a tricky question. This is a tricky question, so pay attention that immovable property with regard to section 5 and 6, and movable property section number 7 and 8. Now, as per section number 5, a person is entitled to possession of a specific immovable property in the manner given in CPC. That as per section number 5, if a person is seeking a possession of an immovable property, then he can opt for the procedure as laid down under CPC. that means to recover specific immovable property, then the person has a choice to bring an action in following ways. What are the following ways? Sir, number one is to bring out a suit based upon title. Based upon title. Title means sir ownership. Ownership. Second option, if he is seeking the possession on the basis of possessory title. Possessory, that means he may not the owner, he is not having a title in his name, but still he is entitled to possession. He is still entitled to possession. Or sir, he was not having the possession, but previously he was possessing the property, and he has been dispossessed unlawfully, without his consent, other than his due course, For example, have you seen that movie Lage Raho Munna Bhai? Now that second innings house, remember? Now in that movie, what happened? Old uncles went to Goa for a trip, and behind that, circuit came to their house and unlawfully dispossessed them. Unlawfully threw their articles, threw their furniture, threw everything out of the house, and took a possession of the property. Now, when they came back from Goa, they want a possession of immovable property. Now they are not the owners; they are just in that movie. They were the tenants. They were the lessee. They were the tenants. Now, can they ask for possession of immovable property on the basis of title? No, sir, they cannot take this. But they can take a possession under section number 6. They can take a possession of immovable property under section number 6, because they have been dispossessed without their consent from the immovable property, otherwise than the due course of law. Sir, if Lucky Singh had to dispossess, then he should have filed a case in the court of law. He should have filed a eviction case. He should have filed a termination of tenancy or whatsoever it is. But unlawfully they have been dispossessed from their property, so their right under section number 6 of Specific Relief Act arises. They can claim a right of possession. They are not claiming the right of ownership. They are claiming the right of possession under section number 6. Okay. Now here, but there are certain limitations which you need to keep in mind under section number 6. That first of all, the remedy under section number 6 is to be availed within the period of 6 months of dispossession. 6 months of dispossession. That means section 6 subsection 2 is clearly saying no suit under this section shall be brought after the expiry of 6 months from the date of dispossession. This is an important point. Note it down. What is the date? 6 months from the date of dispossession. हम 6 months याद रख लेते हैं. 6 months कब से कैलकुलेट करने हैं भूल जाते हैं. 6 months from the date of dispossession. Second limitation, or against government. If that dispossession has been done by the government, then you cannot take a remedy under section number 6. Now, section number 6 subsection 3 is very interesting. It is very interesting. 6 subsection 3 is saying, in the cases of section number 6, no appeal will be allowed, nor any review. That means section number 6 is putting a bar of appeal or review in under section 6 subsection 3. You people know what is appeal and review? Sir, appeal is when you are challenging the order in the higher court. Review is then when you are challenging the order in the same court before the same judge due to some technical error or some apparent mistake or some new facts. That is review. But section 6 subsection 3 is putting a bar to both the remedies. Then sir, iske upar koi remedy nahi hai. Yes, remedy is there, that which Specific Relief Act is not giving. There might be a question in your examination. Section 6 ke khilaf you can go for revision. Under section 115 of CPC. That appeal is not allowed, review is not allowed, but revision under section 115 of CPC is allowed. Is allowed. Okay, understood? Understood? चलिए नेक्स्ट पढ़ते हैं, नेक्स्ट पढ़ते हैं. ओके, एनी डाउट्स अप टू हियर? जस्ट गिव मी अ थम्स अप. गिव मी अ थम्स अप. Thumbs up doesn't mean that you will send me cold drinks. Shalini, Kajal, Shambhavi, understood? Yes or no? Yes. Okay. Chaliye. Next section is recovery of possession of movable property. Of movable property. Again, the structure is same. Section number 7 is talking about a person entitled for possession of specific movable property may recover it in the manner provided by CPC. In the manner provided by CPC. Now, section number 7 and 8. 8 is talking about when a person was having the possession or a control of that of movable property of which he is not the owner. Of which he is not the owner may be compelled. For example, that means, sir, he was not an owner, but he was a bailee. He was a bailee and he is not returning that property to you. Then you can claim the remedy under section number 8. Under section number 8. That means the defendant is having a possession or control over that specific movable property, and he is not the owner, and the person claiming is the immediate possession. Basically, he is entitled for immediate possession. For example, Rahul Jain sir gave his car to a mechanic, to a workshop for repair. For repair. That's a BMW car. Now, who is the owner? Rahul Jain sir. Who is having the possession? That workshop owner. Now, in that situation, he is not returning my car. He is not returning my car due to any reason. If there is a concept of lien, then we'll go with specific. We go for Indian Contract Act. All the money, all the claims has been settled, but he is not giving me my car. Now I can take a remedy under section number 8 for the immediate possession of that specific movable property. Specific movable property. Understood? Understood? Okay. Okay. चलते आगे. Okay. Before we go ahead, one question I have just came into my mind. Sir, can a remedy under section number 8 be lie against the owner? Against the owner? ओनर के खिलाफ सेक्शन 8 की रेमेडी लाई करती है? आंसर इज नो. दिस इज एन इंपॉर्टेंट टॉप पॉइंट. नोट कर लीजिए दैट सेक्शन असूट अंडर सेक्शन नंबर 8 इज नॉट maintainable, is incompetent against the owner. Against the owner, it is filed by the owner but not against the owner. Not against the owner. Okay. Okay, chaliye quickly. Chaliye, next part is specific performance. Very important chapter under Specific Relief Act, that is specific performance, ranging from section number 10 to 19, chapter number 2. Chapter number 2 with regard to specific performance. What do you mean by specific performance? Sir, supposedly Shalini entered into a contract with Rahul Jain sir, whereby Rahul Jain sir will teach him, he will give him coaching for their judiciary exams for 1 lakh rupees. Now, just before the batch has to be started, Rahul Jain sir refused that, okay, sorry, I cannot teach you due to some emergency situation, or I have got some job, or I'm busy, or I am occupied somewhere. You take compensation. Shalini is of the opinion that, sir, what will I do with the compensation? My career is at stake. Just few weeks ahead, I am having my examination. I will not get up coaching at this 0 hour. Where will I go? And this is cheating and not. Now I am saying I'll give you compensation. I'll give you damages. Now Shalini is insisting that, Lord, in this situation, compensation, damages are not sufficient. Damages are not sufficient. They will not be suitable for this contract, I want a specific performance. That means the court will compel, Rahul Jain that just do your duty as enshrined under your contract, as enshrined under terms and condition of a contract. You are supposed to teach him. You are supposed to teach him. Now, sir, मैं पढ़ा ही नहीं सकता. Sir, it is not possible for me to teach. I am already occupied. I do not have time. अगर ऐसी सिचुएशन हुई भी, इफ यू कंपेल मी, बैठा रहूंगा, क्या चेक करोगे कि मैं इसको पढ़ा रहा हूं कि नहीं पढ़ा रहा, गलत पढ़ा दूंगा, सही पढ़ाया ही नहीं है. Now in that eventuality there is a question of dispute. Court is saying, Rahul, what if we compel Mr. Jain, but later on he is coming to you and just sitting with a cup of tea in his hand, or if he's teaching all wrong, सब कुछ उल्टा पुल्टा, सब गलत समझा रहे हैं. Now it is a situation. Now under this situation, there are certain situations where contract cannot be specifically enforced. There are situations where contract cannot be specifically enforced. Now, as per section 14, subsection A, Rahul Jain sir says, sir, my lord, I cannot teach, but my brother Abhishek, he is a good person, he is a good teacher, he is having a good experience of teaching in university. I am unavailable, but I'll say to Abhishek, he will teach you. He will teach Shalini. Now, this is a concept of substituted performance. This is a concept of substituted performance. Now, Shalini is saying, okay, sir, fine. Kya kare? I am accommodating with you. So, Abhishek will teach in place of me. In place of me. This is the situation where party has obtained substituted performance of contract. Substituted performance of contract, and therefore this specific performance, this contract between Shalini and Rahul Jain cannot be enforced. Number 2, सर अभी आपने कहा कि आप पढ़ा तो दोगे, लेकिन कोर्ट कोई बैठ के देखेगा थोड़ी ना. There are certain situation where there is a performance of a continuous duty. There is a performance of a continuous duty, and the court cannot supervise it. The court cannot supervise it. Supposedly, this teaching has to go, this classes has to go for 2 weeks. Now, is it practical that the judge will sit with us that and will check that Rahul Jain sir सही पढ़ा भी रहे हैं नहीं, या सिर्फ टाइम पास कर रहे हैं, सिर्फ देखे ही जा रहे हैं? ऐसा तो नहीं किया जा सकता. Court cannot supervise this thing because it's a continuous duty. Under that eventuality, contract cannot be specifically enforced. Contract cannot be specifically enforced. Okay. Next, sir, sometimes the nature is such of situations which cannot be specifically enforced, or due to some personal qualifications, the contract cannot be specifically enforced. But apart from that, there are certain bars as well. There are certain bars as well as under section number 16. Under section number 16, that there are under section number 16, guys, important point, specific performance of a contract cannot be enforced in favor of certain category of person. There are certain category of a person. There are certain persons where this specific performance cannot be enforced. Where, sir? Where a person has obtained this specific substituted performance. Sir, Shalini ne already substituted performance enjoy कर लिए, तो what, there is no concept of specific performance. Or a person who has become incapable or commits any wrong in that, or a person who becomes incapable or commits any wrong means, sir, उसके खिलाफ उससे एक specific performance को हम लागू नहीं कर सकते. Specific performance लागू नहीं कर सकते. सर ये तो समझ आ गया. Who are the persons who are entitled for specific performance? The answer to this question lies in section number 15, that who can obtain specific performance. Sir, party to the suit, the representative to the party, principal. Now, there are certain situations which have been given under section number 15, that who can obtain specific performance. Who can obtain specific performance. Okay, any doubts up to here? Just write it in the chat box. Apart from that, sir, when we are talking about specific performance, Under section 17, there is a contract to sell or let property when not specifically enforceable. Section number 17 is talking about a contract whereby the contract is related to selling or leasing out of a property. Now if that contract supposedly, just clear, let me clear the screen. So supposedly Rahul Jain entered into a contract with Abhishek whereby I will sell a property to him, whereby I will sell a property to him. Now I am not selling him. I am not selling him. Abhishek is of the opinion that नहीं मुझे तो ये property लेनी ही है. I will take this property. Now, sir, okay, then he will file specific performance. But under section 17, there are certain situations where you cannot specifically enforce this contract. Sir, how? ना सर सब राहुल जैन के पास तो वो प्रॉपर्टी ही नहीं है. राहुल जैन इज इनकॉम्पिटेंट टू सेल दैट प्रॉपर्टी. ही इज नॉट हैविंग द परफेक्ट टाइटल. He is not where he is not having the perfect title. His title is doubtful. So how can you claim this specific performance from me under section number 70? Section number 70. Okay. Okay. Chaliye. Now, apart from this, there are certain situations under section number 18 and 19 with regard to specific performance, which you can just read it out in that situation. Okay. Now, sir, very important topic, very important section, chapter number 3 of Specific Relief Act, covering only one section, section number 26, which is related to rectification, which is related to rectification. What do you mean by rectification? What is rectification? Write your answer in the chat box. Write your answer in the chat box. What do you mean by rectification? I'm waiting. Anyone? रेक्टिफिकेशन का मतलब, रेक्टिफिकेशन का मतलब बताइए. बताइए. बचपन में करते थे भूल सुधार, याद आया? बचपन में करते थे भूल सुधार, करेक्शन, करेक्शन, correction. That is rectification. That is rectification. Basically, rectification is a correction of a document. Why it is necessary? It is necessary because that document is not correctly expressing the common intention of the parties. So why that contract was executed? Contract was executed for the lawful or for the bona fide intention, but somehow due to fraud or mutual mistake of the parties, the contract or that instrument is not inferring the true intention, the real intention of the parties, then in such an eventuality, we can approach the court of law under section number 26 of Specific Relief Act for rectification of instruments, Okay, now it is saying when there has been a fraud or mutual mistake. These are the two grounds which have been mentioned under section number 26, that on the cases of fraud or mutual mistake, only in that eventuality you can claim the remedy for rectification when this fraud and mutual mistake is not giving birth to the real intention of the parties. It is not clearing the real intention of the parties. Then in such a situation, either party or their representatives may approach the court of law for rectification of instrument under section number 26. Now, one thing is important to note, that this section is not applicable to article of association of a company. It is not applicable. Now we are just recalling the essentials of rectification. There must be a genuine agreement between the parties. That genuine agreement is different from the expressed agreement. there was a fraud or a mutual mistake between the parties. Due to that fraud or mutual mistake, the real intention is not coming out. Now, the court has to determine whether the intention of the parties is a consequence of that contract or not. Now, if it is a unilateral mistake, if it is a unilateral mistake, then then it will not be under the scope of ambit of section number 26. बार बार कह रहा हूं, it should be a mutual mistake and the end of both the parties, mistake on the end of both the parties. If it is from one side, then it should have been a fraud intention, it should have been a fraud. If it would have single unilateral mistake, then it will not come under this category, it will not come under this category. Now, one thing is important to note here, that supposedly a case is going on with regard to that particular contract. Now, during the suit, the party realizes that there is a requirement of rectification. अब कोर्ट में तो केस हो चुका है regarding enforcement of contract, but they need rectification as well. Then, in such an eventuality, the contract will be first rectified, then it will be enforced. For that purpose, the party has to specifically make a mention in the pleadings, that he has to specifically pray in the pleadings for rectification, and if that is allowed, then the court will enforce this contract. Then the court will enforce the contract. Okay, okay, yes or no? ओके सर, व्हाट इज फ्रॉड और म्यूचुअल मिस्टेक? सर, फ्रॉड हम लोगों ने इंडियन कॉन्ट्रैक्ट एक्ट के अंदर करा है. व्हाट इज फ्रॉड? व्हेन देयर इज अ deliberate misrepresentation or active concealment of fact, or with an intention to deceive somebody, or any other act to fit to deceive, or any omission of law which is specifically declared as fraudulent, that is fraud. That is fraud. Mutual mistake means mistake on the part of both the parties, mistake on the part of both the parties. Okay, sir. Sir, is it a discretionary power of the court, section number 26? Yes, it is the discretion of the court to grant the relief of rectification. It is the discretion of the court to grant the relief of rectification as per section 20 subsection 2. That the closing lines are, the discretion lies with the court for cancellation of instrument. Okay, sir, is there any time limit for rectification? Now, ध्यान से समझिएगा guys, section number 26 is not fixing up the time, but for limitation period, it is the time period will start from date of discovery of fraud or mistake. Discovery of fraud or mistake, this is an important point, इसको note कर लीजिए. The time period of limitation will start from the date of discovery of fraud or mutual mistake. तभी से हमारा टाइम पीरियड शुरू होगा. ओके, ओके, अंडरस्टूड. Understood? Give me a thumbs up that okay, good to go. Guys, please be interactive in the class, it feels nice. At least some likes and all. Sir, okay, fine, we are understood. Okay, next chapter is chapter number 4. Chapter number 4 of specific relief act, talking about rescission of contract. Talking about rescission of contract instrument. What is rescission? What is rescission? Tell me. Rescinding, rescission, what does it mean? Tell me rescission means. Termination of contract. Very nice. Anyone else? Anyone else? Rescission. Now there are certain situations when which we did in contract act a few days back. The contract may be valid or void. The contract may be valid or void, but there are certain eventualities, there are certain situations where you are standing here, you have to decide the fate of the contract, either to make it valid or to make it void. That this situation is known as voidable. This situation is known as voidable. That means the aggrieved party is having an option to decide the fate of the contract. He can either choose to make the contract valid or void. Remember the poem, The Road Not Taken? This is the exactly thing, that the road not taken. You have to choose either of the path. You have to choose either of the path. Now, sir, under Indian Contract Act, there was very situations where the consent was not free. So by section 19, 19A, the contract was voidable. And there were many situations under section 39, 53, 55 of Indian Contract Act. The contract becomes voidable, uh, unconsignable bargain, etc., etc. Now, once we are choosing the contract to make it void, once we are choosing to make the contract void, that means we are rescinding the contract. That means we are rescinding the contract. Now, once we are rescinding the contract, then I have to give a notice to the other party, which is expressing my intention, to resign the contract. Sir, if the notice should be in particular format, no, there is no particular format of the notice. Basically, it is the act of conveying, it is the act of communication. Sir, हर relation में communication जरूरी है. So there should be a communication which is expressing your desire to resign the contract. Now, sometimes specific relief act is talking about a situation where a plaintiff is praying for rescission of the contract. It is rescission of the contract where the contract cannot be specifically enforced. Then the plaintiff is asking for praying for rescission of the contract. Rescission of the contract. Okay. Now, when the court is of the opinion that we should resign the contract, that on adjudging the rescission of the contract, the court may require the party to whom is this relief has granted, he should restore the benefits. This the principle of restoration, which we have done in the class of Indian Contract Act. The court will apply the principles of restoration. The court will apply the principles of restoration on the basis of equity, that okay, we are undoing it, then therefore you go for restoration, जो हमने section 64 of Indian Contract Act में करा है. Section 64 is the Indian Contract के अंदर एक similar provision है. Okay, understood? Decision में सिर्फ इतना सा करना है, decision में इतना सा. Now, which is very important is cancellation. Now, before we proceed further, tell me the difference between rescission and cancellation. This is an important question. What is the difference between rescission and cancellation? Now, in the chat box, you are writing rescission means termination of contract. What do you mean by cancellation of an instrument? What is the difference between the two? Tell me. I'm waiting. What is the difference between rescission and cancellation? What is the difference between rescission and cancellation? Type, I'm waiting. Difference between rescission and cancellation. Anyone? No one, no one, no one, no one, no one. Anyone try, please? Chaliye. Under rescission of a contract, we are putting an end to the legal entity of the contract. We are terminating the contract. That means we are putting an end to the legal existence of the contract. But when we are talking about cancellation, we are talking about cancellation of instrument. We are talking about cancellation of instrument. Now, this cancellation of instrument is a step further. Is a step further that okay, fine, the contract has been terminated, the contract has been rescinded. Now we will cancel the instrument as well. Instrument means the document as well. Now, what are the situations? Now, as per section number 31, as per section number 31, that when the person is of the opinion that first of all there is a written agreement, there is a written agreement which is either void or voidable, which is either void or voidable. Now, the plaintiff is having a reasonable apprehension that there can be a serious injury. There can be a serious injury from being left unattended. If this instrument is left outstanding, then I am having a serious apprehension. अभी हुई नहीं है, हमको इसका भय है, हमको इसका खतरा है. We are having a serious apprehension of a serious injury that if this document, if this instrument is left unattended, then we may suffer a serious injury. Then in such a situation, if all these conditions are satisfied, the court will think and consider it reasonable or proper to administer protective and preventive justice. This principle, this section is based upon preventive justice. तो ठीक है, इसको कैंसिल कर देते हैं, कल को प्रॉब्लम ना आए. Supposedly, Rahul Jain entered into a contract with railway. Now Rahul Jain played a fraud with railway, and due to which the contract becomes voidable. Now Indian Railways turned that contract void. Now Indian Railways of the opinion that it might be very serious offense अगर हमने ये contract ऐसे ही छोड़ दिया. Rahul Jain may take an undue advantage of this particular instrument in future, even from railways itself. So we should cancel that instrument as well. And then they will approach the court of law under section number 31 for cancellation of instrument. Okay. Understood? Now, sir, there can be a partial cancellation as well. Yes. Section number 32 is talking about partial cancellation as well. Now, as per section 32, if the court is under discretion that we are not cancelling the entire instrument, we are cancelling the part of that instrument, the part of the instrument which is not right, then in that eventuality there can be a situation, but providedly that part are distinct and separable. If it is distinct and separable means which can be separated, then the court may order for partial cancellation of an instrument. That means the instrument which has been cancelled, it has having no existence, but which is perfectly fine, that is purely enforceable. Now again, there will be a principle of restoration. That it is the obligation, the person who has received any advantage under void agreement or a contract which has become void, just like section 65 of Indian Contract Act, he is under obligation to restore the benefits, to restore the advantages which we have received. Okay, what is the purpose of this particular section regarding cancellation? Now, the purpose is, the primary objective of this provision lies that justice to participants of a instrument should be given, it should be given in preventive form, in the preventive form. Okay, okay, yes or no? Okay, sir, now here a situation comes. How many of you have done the cases of concept of minus position in Indian Contract Act? Minus position on Indian Contract Act, yaad hai? There were three cases. Firstly, we started the concept with Mohori Bibi versus Dharmodas Ghosh. Then we were having a case of Leslie versus Shale. Then two different opinions of Lahore High Court and Allahabad High Court. Khan Gul versus Lakha Singh. अयोध्या प्रसाद वर्सेस चंदन लाल. सर शादी लाल, याद आया? याद आ गया? Now these two different, in Mohri Bibi and Dharmodas Ghosh, they were saying, first of all, any agreement with the minor is void. No restoration under section 64, 65 of Indian Contract Act. No benefit under Specific Relief Act. No benefit under Specific Relief Act. This was done. But later on, Lahore High Court in Khanbul versus Lakha Singh and Ajodhya Prasad versus Chandan Lal gave entirely different opinions, and this gave a confusion in the country. After that, Section 41 of Specific Relief Act came into picture, which sorted the position of a minor with regard to Indian Contract Act, which is as such. Number one, any agreement with minor is void. That is the settled position, that any agreement with minor is void. But if minor is going as plaintiff, then the court may ask him to restore the benefits and make compensation as justice may require. As justice may require. ये पॉइंट याद रखना, ये कॉन्ट्रैक्ट एक्ट में भी काम आता है और स्पेसिफिक रिलीफ में भी काम आता है. Listen to my words carefully. As per SRA, if a minor is going for cancellation of an instrument, if he is going as a plaintiff, if minor is going as a plaintiff, then the court may ask him to restore the benefit and make compensation as justice may require. As justice may require. जितना मर्जी हम कोर्ट कह सकता है. But if a minor is going as defendant, then the court may ask him to restore the benefit to the extent his estate was benefited. To the extent his estate was benefited thereby. उस डील से उसको कितना फायदा हुआ है, अब उतना तक ही आप रिस्टोरेशन अलाउ कर सकते हैं. उतना तक ही रिस्टोरेशन अलाउ कर सकते हैं. सो एज पर सेक्शन नंबर 41, you need to pay attention towards the position of a minor while approaching the court. Either he is going as plaintiff or defendant. It will make a huge difference. It will make a huge difference. Okay, understood? चले आगे. चलते हैं जी. नेक्स्ट इज सर declaratory decrees. Declaratory decrees under chapter number 4. Chapter number 4, declaratory decrees, section 34 and 35. What is declaration? What do you mean by declaration in general? Sir, declaration means you are acknowledging something. You are certifying something. Yes. So what is declaratory decree? A declaratory is a decree which is declaring a right of a plaintiff. It is acknowledging the legal character of or a property to the plaintiff. It is avoiding all possible future litigations, controversies, dispute. कोर्ट ऐसे नहीं, ये इसका है, हम कह रहे हैं इसका है तो इसका है. But this declaratory decree is very important. It is very important. Now, for taking a declaratory decree, there must be certain essential. The person who is claiming declaratory decree must be entitled to a legal character character or a legal right or a interest in the property or in the interest or a property whatsoever, पहले वो राइट होना भी तो चाहिए जिसको एक्नॉलेज करना है, जिसको एक्नॉलेज करना है वो राइट होना भी तो चाहिए. नंबर वन, the right is there but the other party is denying that right, the other party is denying the right or is interested in denying the right or is interested in denying the right, then court may pass a declaratory decree by way of discretion, again a discretion, again a discretion. Okay, for example, Rahul Jain sir is having a property in a village, big village, purani baap dada ki properties, it's an ancestral property. Now all villagers came and think that it is an old property. Rahul Jain sir stays in a metropolitan city, but in village I am having a big property. Now people think that it is a property of a community, it is not a property of Mr. Jain. उनको मैं समझा समझा के थक गया दैट सर ये मेरी प्रॉपर्टी है, बाप दादा की जमीन है, तब से चल रही है. Now I can approach the court of law that Lord, this is my property, see this is my interest in the property, these are the legal rights I am having with this property, these are the documents, and the villagers or inhabitants of locality are claiming this right. और उसके ऊपर से रास्ता बना रहे हैं, कभी मेला लगा लेते हैं वहां पर, कभी कुछ लगा लेते हैं. Now कोर्ट, क्या कोर्ट कोई नया राइट बना रहा है? नो. डिक्लेरेटरी डिक्री के अंदर इस चीज को ध्यान रखना है, द कोर्ट इज नॉट गिविंग बर्थ टू एनी राइट, कोर्ट इज नॉट क्रिएटिंग एनी राइट, कोर्ट इज नॉट creating any right or it is not extinguishing it, it is just acknowledging, it is just acknowledging on the persons who are denying their interest. The court is just acknowledging that yes, it is a right of Mr. Jain over this property, over this property. Okay, okay, basically legal character, I was having the legal character, the court is just acknowledging it, the court is just acknowledging it. Okay, sir, it is very important to note that when you are attempting a question regarding it, you can note it down that this declaratory decree is available when the plaintiff is having a present and substituting right. The plaintiff is having a present right at the time of date of suit and decree. That means the court cannot make a declaration upon a right which may arise in future. No, the court will not grant a declaratory decree for a right which may arise in future, which may arise in future. No. For example, Rahul Jain is having a will of his father. Father is still alive, but I am presenting that will, that Lord, as per this will, I will be the owner of this property, so issue a declaratory decree. No, that interest is dependent upon some future event, so I will not get a declaratory decree, I will get declaratory decree at the time on the basis of a present and subsisting right. ये point याद रखना है, भूलना नहीं है, नोट करके रख लीजिए, नोट करके रख लीजिए. Now what is the effect of this declaratory decree? Now when their declaratory decree has been passed, it is binding only on the parties to the suit first of all. Now, or sir, is it bound upon some general public as well or not? Is it bound upon the general public or it is bound upon the parties to the suit? See, the declaratory decree first of all binds the party to the suit, trustees at the time of suit, or the persons claiming through the parties. Plus, it is not applicable to the general public. It is binding upon the parties to the suit, trustees, or claiming the person claiming claiming through the parties. That means the declaratory decree is a decree in personam. In personam, it is not in rem. You people know what is in personam or in rem. In rem means when you are having it is against all the people. For a particular person. The declaratory decree is in personam, not rem. Okay, understood? Understood? गिविंग यू 2 मिनट्स, जस्ट सी, फिर आगे चलते हैं। शालिनी, काजल, शांभवी। ओके, नेक्स्ट चैप्टर वेरी इंपॉर्टेंट चैप्टर एंड स्पेसिफिक रिलीफ में इस्तेमाल होने वाला सबसे ज्यादा चैप्टर, दैट इज इंजंक्शन। व्हाट इज इंजंक्शन? व्हाट डू यू मीन बाय इंजंक्शन इन कॉमन लैंग्वेज? राइट इट डाउन, write it down in the chat box. What do you mean by injunction? What do you mean by injunction? Hi Priyanka, what do you mean by injunction? सर इंजंक्शन का मतलब बताइए भाई। सर रिस्ट्रेनिंग समवन फ्रॉम डूइंग थिंग और नॉट टू डू थिंग। आम भाषा में क्या बोलते हैं इसको? हम स्टे ऑर्डर। आम भाषा में क्या बोलते हैं? स्टे ऑर्डर। फॉर एग्जाम्पल, फॉर एग्जाम्पल, राहुल जैन entered into a contract with Kapil Sharma, entered into a contract with Kapil Sharma that he has to perform on 31st December and I am the organizer. Now, one fine day, I came to know that Mr. Kapil Sharma is going abroad on 30th of December. Why, sir? Tomorrow you are having a concert to perform. I have sold the tickets. I am the organizer. If you do not turn up, I'll be in a huge trouble. So I approached the court of law. Sir, Lord, please issue a direction of injunction against Mr. Kapil Sharma that he should not fly abroad. Why, sir? Because I am having a concert scheduled for 31st night and he has to be present over there. Otherwise, I will be in a big trouble. Basically, you are claiming a stay order. You are claiming a stay order. Sir, supposedly, Rahul Jain and his brothers are in dispute of some property. Now, in dispute of some property. Now, say a house. Now, remaining brothers are of opinion that Mr. Jain will sell off this property. So they can approach this court of law that till the time our case is settled, till the time the case of partition is settled, this property should not be disposed of. This property should not be disposed of. So it is also claiming injunction. It is basically injunction is restraining somebody from doing a particular act or not. Doing a particular act or not. Now, injunction is of two types. Number one, perpetual or temporary. Temporary or perpetual. What is temporary and what is perpetual? Simply, sir. Simply, इसका क्या मतलब है? टेम्परेरी, perpetual और मैंडेटरी भी हम कई बार पढ़ते हैं. What is perpetual or what is temporary? Temporary injunctions are those injunctions which are to continue for a specified time or till the further orders of the court or up to a particular date or up to a next date of hearing. That is temporary injunction. That is temporary injunction. What is perpetual injunction? Can be granted by decree upon the merits of the case, and basically the defendant is indefinitely allowed to enjoy the right from commission of any act or basically for an indefinite period. That is perpetual, continuously. Temporary injunction को हम क्या बोलते हैं? स्टेटस क्यो. क्या बोलते हैं? स्टेटस क्यो. जैसा आज है वैसा ही रखिए, यथास्थिति बरकरार रहे. Thing which is there on the date of order today, that means जैसी आज 12 दिसंबर को स्टेटस है वैसा ही बना रहेगा, वैसा ही बना रहेगा. ओके, ओके. So basically, this injunction is a preventive relief. It's a preventive relief. How this preventive relief is given? It is a preventive relief. Now, when the question of preventive relief or injunction comes up before the court of law, now court of law has to see three things. Number one, prima facie case, balance of convenience, and irreparable loss. Now, these three things are quite wide, quite large, quite big. Now, अभी हम केस को डिटेल में नहीं पढ़ रहे हैं. We are just considering it prima facie. We are not going into the detailed merits of the case. We are prima facie looking at the case and looking at that if this injunction is not granted, then in such an eventuality, the other party will suffer an irreparable loss which cannot be undone. Next, the court is issuing injunction to before after seeing that balance of convenience in the favor of plaintiff or not in the favor of other party. If all three factors are there, then we can issue a preventive relief in terms of injunction. Okay. Okay. Now, when we are talking of an injunction, it may be temporary, it may be perpetual. Now, when the court is giving a perpetual injunction, only in the situation where the defendant is the trustee of the property. Defendant is a trustee of the property of plaintiff. इसको लिख लीजिए, याद रहेगा. Just a second. Perpetual injunction may be granted if defendant is trustee of the property of plaintiff. plaintiff की प्रॉपर्टी का ट्रस्टी है. Number two, there is no standard for ascertaining the actual loss or damage caused or likely to be caused. No standard to ascertain the actual loss or likely to be caused. Number three, invasion is such that compensation is not an adequate relief. Compensation is not an adequate relief. Next, where injunction is required to avoid multiplicity of legal proceedings, multiplicity of litigations. In either of the four situations, the court may grant perpetual injunction. Number one, when the defendant is the trustee of the property of plaintiff. Number two, when there is no standard of ascertaining the actual damage caused or likely to be caused, or there is compensation is not an actual remedy, or where the injunction is necessary to avoid multiplicity of litigation. Okay. Sir, there are certain situations where injunction cannot be granted. There are certain situation where injunction cannot be granted as per section number 41, where sir restrain any person from applying to legislative body or instituting a legal case or pursuing a criminal matter, or there has been a continuous breach. So there are certain situations under section number 41 which is giving you a bar that in that eventuality injunction cannot be granted. Okay. Next is mandatory injunction. What is mandatory injunction as per section number 39? When to prevent the breach of an obligation or to compel the performance of the contract, the court may grant an injunction to prevent the breach and compel the performance of the requisite act. Basically, it's a hybrid thing. Basically there are two models in mandatory injunction. There must be an act which is mandatory to prevent the breach of the contract. Number one, we are preventing the breach of the contract. Side by side, the court is capable of enforcing it. We are making it enforcing it. We are making it, enforcing it. So it is in the discretion to grant a mandatory injunction. Granting mandatory injunction. Understood? Understood? Any doubts? Any doubts? Guys, please ask. I'm waiting. Okay. Sir, as you just told us that there was an amendment act which came in 2018. So there were certain amendments were also made under in specific relief act by way of that amendment act. So what were those amendments? Do you have any idea? Please ask. There were certain amendments which were done by the Amendment Act of 2018. Now, basically, what happened earlier? Basically, earlier, damages were the general rule. Damages were the general rule, and specific performance was an exception. Specific relief was an exception, and damages was the general rule. But later on, with the passage of Amendment Act, the position got changed. The position got changed, and with this, specific performance became the general rule, and damages became the exceptions. Damages became the exceptions. Now, basically, what was this? This amended Act of 2018 was based upon a report of expert committee constituted in 2016. Now, in that report, that committees recommended that there should be a change in approach. They're changing approach. Number one, they also said there should be a guidelines for reducing the discretion of the court. Now, when we are talking about changing approach, we have seen that earlier damages was the general rule and specific performance was the exception. Now, this we have changed. Now, it is a well settled position that amendment, which is in nature of clarification or declaratory part, is retrospective. Is retrospective. Now, there might be a question when we are talking about declaratory part, it is a retrospective, having a retrospective effect where the amendment is altering substantial rights of parties. It is prospective. It is prospective. You know what is prospective and retrospective. Retrospective means taking effect from back date. Prospective is so future date. Now the question of law is that whether this amendment act, specific relief act, amendment act, is prospective in nature or retrospective in nature. Now, it is a settled position of law is that specific relief act should be viewed as prospectively, should be viewed as prospectively, not retrospectively. Okay, this question comes many times this question comes that it is retrospective or prospective. It is prospective. Now, there were certain amendments made out in 2018 act. Under those amendments, we'll just do it in quickly. As per section number 10, specific performance is no longer a discretionary. Specific performance is no longer a discretionary. The word is shall be enforced by the court. Shall be enforced. Number one. Number two, monetary compensation is an exception. जो भी हमने यहाँ पढ़ा. Monetary compensation is an exception under section number 11. Under section number 11. Now, and under section number 14, we have studied that the situation where the contract cannot be specifically enforced. Prior to this amendment act, the list under section number 14 was quite large. After the enactment of Amendment Act 2018, the list under section number 14, whereby the contracts cannot be specifically enforced, is substantially reduced. That means there has been a reduction in the category of contracts which cannot be specifically enforced. Apart from this, 14A has been specifically inserted, whereby it is giving a power to the courts to engage experts in assisting the matter. This is an important point. 14A was specifically inserted, which is giving a power to the court to engage expert for assisting in a specific issue. Now, the next point is, when we are talking about section number 15, when we are talking about section number 15, which talks about who may obtain specific performance, now it has included many categories, just like LLP. Just like LLP, now LLP can also obtain specific performance. Specific performance. Okay. Now there, similarly substituted performance has been dealt with. Similarly substituted performance dealt with. In addition to it, very important guys, note it down, section 20A, 20B and 20C related to infrastructure project contracts. 20A, 20B, 20C. Now there has been an insertion of 20A, B, C, which are special provision for contracts relating to infrastructures. Okay. Now, next, as per section number 21, now no compensation in substitution of specific performance. No compensation for specific performance. Okay. Anyone else? Any doubts up to here? Basically, the main objective of this amendment act was to reduce the intervention of the court and to ensure public work smoothly. This thing on the ABC. Now, okay. Anything else? Any doubts? Okay, guys, I think this is your revision for specific relief act. Any doubts from this particular chapter? जो points हमने करें that are most important for your examination point of view as well, tricky points as well, which you need to keep in mind, while preparing for examination. Don't forget it. Section particular regarding to movable, immovable, rescission, rectification, cancellation, इंजंक्शन जो हम लोगों ने क्लास के अंदर करे हैं, that those are the most important sections. If you have any doubts, I am sitting here for 5 more minutes. Mandatory injunction. Yeah, sure. See, mandatory injunction is a situation where the court is of the opinion that the act it is necessary to prevent the breach of the contract. Number one, that it is necessary to prevent the breach of the contract. Number one, now it is also there, the court is capable of enforcing it. Instead of preventing the breach, we are enforcing the contract. Basically two elements are there. एक तरफ तो हम उसको ब्रीच करने से रोक रहे हैं, साथ साथ उसको एनफोर्स भी कर रहे हैं. ओके. Basically, court is giving a direction to prevent breach of contract as well as compelling the performance of it. That is mandatory injunction. Okay, Priyanka. For example, Priyanka entered into a contract with Rahul Jain sir, whereby she has to supply me some books. She is having a publishing house. Now, I am having a batch to start from 1st of April. Or I came to know on 1st of March that she has entered into a contract with Arihant Publications. She is printing books from there. I approached the court of law that my order was already there and I know the capacity of publishing house. She cannot fulfill both the orders. Now the court will say, okay, first of all, Priyanka, you are abstain from taking a contract or executing a contract from Arihant. Number one. Number two, you are compelled to deliver the books of Mr. Jain's coaching center by the due date. So two elements were there. Mandatory injunctions. Okay. Okay, guys, next doubt. Next doubt, please ask. Please type it in the chat box. Whatsoever doubts are there. Last call, guys. Any doubts? Okay, one doubt is here regarding section number 13. Supposedly, who is asking this doubt? Aish. Okay. Now, supposedly, as per section number 13, Rahul Jain entered into a contract with Abhishek whereby I will sell my property to him. I will sell my property to him. Now, supposedly, I am not having a perfect title of that property. Okay, fine, sir. You are not having a perfect title, so this contract cannot be specifically enforced because when you are not having a perfect title, how can it be enforced? Yes, sir. What if later on Rahul Jain get a better title? Now Rahul Jain is having a perfect title by virtue of some transfer, by virtue of some legal implications. Now in that eventuality, Abhishek can ask for specific performance कि अब तो आपके पास perfect title आ गया है and we were already in a contract, so I am enforcing the contract by way of specific performance, by way of specific performance. Okay. Okay. Okay, I guess this is all for today. All the best for your examination. Please take care and please जो जो पॉइंट्स याद रखने को कहे हैं उसको अच्छे से याद रखिएगा, भूलिएगा नहीं. ध्यान रखिएगा. ट्रिकी पॉइंट्स, स्पेसिफिक सेक्शंस, चैप्टर्स, स्ट्रक्चर ऑफ दिस एक्ट, ये याद रखना है. ओके, टेक केयर, बाय बाय, एंजॉय योर स्टडीज.